The golden ticket. Get out of the Clark County Family Court. Fight that reasonable efforts were not made. Here's the golden ticket. You must argue that they did not make reasonable efforts, which caseworkers are legally required to do this whenever possible, and to refer for court intervention and placement of children in out-of-home care, foster care, only when children cannot be kept safely within their own homes. And according to Jennifer Coleman, Clark County District Attorney, in a YouTube video entitled CIP Compelling Reasons and Termination of Parental Rights TPR, hear what she has to say. What are reasonable efforts? Not defined in federal law. Yes, it does. 45 CFR 1356.21 b. Defined in Nevada law, NRS 432b.393, 4. Reasonable efforts have been made if an agency that provides child welfare services to children with legal custody of a child has exercised diligence and care in arranging appropriate, accessible, and available services that are designed to improve the ability of a family to provide a safe and stable home for each child in the family with health and safety of the child as its paramount concern. So, when are reasonable efforts required? There's 3 situations in which reasonable efforts are required. First is to prevent the removal of a child from the home. Second is to make it possible for a child to return home once removed. And third is to finalize the permanency plan for the child. A couple key things I'd like to point out is specifically when we're talking about removing the child from the home. Reasonable efforts findings are required to be made under federal law within 60 days of the child being removed from the home. So, it is paramount that these findings be made in the first order after a child's been removed, and that can be one of 2 orders, depending on how the child was removed. The first situation is when a child is removed by way of warrant order. That warrant order must have the reasonable efforts finding in it, and it will be the first order filed in the case. The other situation is when a child is removed due to exigent circumstances, and the child had to be removed to be able to protect their immediate health or welfare. In that situation, the first order entered in the case is the order from the protective custody or the preliminary protective hearing, depending on which jurisdiction you are in, and so it be paramount in those cases that the reasonable efforts findings be put into that part. What happens is if the finding is not in the first order entered in the case, the agency will lose, or the child will lose, title for eligibility funding reimbursement from the federal government for the life of the case. Once this mistake is made, it cannot be fixed. Reimbursement would be lost for the entire life, and there's no way to remedy it. So it's really important, especially for the judicial officers, to make sure that when they are issuing those orders, that the language is in there,